All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and court practice for immersion. The courtroom on the third floor of Atlas Hall smells faintly of furniture polish and old carpet, and by 3:45 p.m. on a grey Thursday afternoon, the gallery is fuller than it should be for a simple sentencing hearing. Defense Attorney North sits beside her client, Defendant Rook, his hands folded on the counsel table, his breathing shallow and uneven, as Judge Keystone scans the plea agreement one more time under the hum of the fluorescent lights overhead. Prosecutor Slate stands at the podium, hands loose at her sides, expression professionally neutral, but there's an edge in her posture, something tense about the way she's holding her weight on her front foot, ready for something that hasn't quite happened yet. The plea was negotiated 3 weeks ago, hammered out over 5 separate meetings and a dozen phone calls. Rook would plead guilty to 1 count of aggravated assault with a deadly weapon in exchange for a recommendation of probation and anger management counseling. No jail time, no felony-level consequence that would gut his custody arrangement with his daughter or cost him the electrician's license he's held for 15 years. It was, by any measure, a lenient deal for a case involving a knife and a parking lot confrontation that left another man with stitches across his forearm. But leniency, in this courtroom, is about to collide with something else entirely. The invisible line between advocacy and impropriety, and the procedural machinery that grinds into motion the moment that line is crossed. Keystone leans back in her high-backed leather chair and says, without preamble, her voice cutting through the low murmur of the gallery, "Counsel, before I accept this plea and move to sentencing, I need clarity on something." North tenses, her spine straightening, her pen hovering over the yellow legal pad in front of her. Slate shifts her weight, her eyes narrowing slightly. The judge continues, her tone measured but firm. "Ms. North, 3 days ago you and I had a conversation in my chambers regarding scheduling in another matter, State v. Carver. You referenced this case in passing, suggesting that your client here, Mr. Rook, had certain personal circumstances that made incarceration particularly damaging. I don't recall Ms. Slate being present for that exchange." The words fall into the courtroom like stones into still water, and North's face drains of color because she knows exactly what this is. An accusation of ex parte communication, a breach of the ethical wall that keeps judicial decisions insulated from one-sided advocacy, and it's happening on the record, in front of her client, in front of opposing counsel, in front of the court reporter whose fingers are already flying across the stenotype machine, preserving every syllable for posterity and potential appeal. Before you wonder how a routine plea can spiral into an appellate nightmare in under 10 minutes, hit subscribe. You'll want to see how procedure becomes a weapon when a judge suspects counsel crossed a line she can never uncross, and how a single 30-second conversation can turn a done deal into a courtroom battlefield where the stakes aren't just one defendant's freedom, but the integrity of the system itself. The case itself began 4 months earlier on a bright Saturday morning in a parking lot outside a hardware store in Riverbend, a mid-sized city in Granite County where everyone knows everyone else's business and grudges tend to simmer for years before they boil over. Rook and another customer, a man named Tenant, argued over a parking space. Rook believed he'd been waiting for it. Tenant believed he'd gotten there first. And then over who had the right to squeeze past whom in the narrow lumber aisle inside the store. And finally, back in the lot again 20 minutes later, over an insult about intelligence and parentage that neither man would later be able to reconstruct clearly under oath. What was clear, what the security camera footage showed in grainy black and white, was that Rook produced a folding knife from his pocket, a 3-inch blade he later said he used for work, flicked it open with a practiced motion, and waved it in Tenant's direction, while shouting words the camera couldn't capture, but witnesses later described as threats to cut or gut the other man. Tennant stumbled backward, caught his arm on the sharp edge of a truck bed behind him, and sustained a shallow laceration running from elbow to wrist. Defensive wound or accident, the medical examiner's notes didn't specify, and the ambiguity would become crucial later in plea negotiations. Tennant called the police from the parking lot, his shirt soaked with blood that looked worse than the injury actually was. Rook was arrested at his home 2 hours later, the knife still in his glove box, and charged with aggravated assault with a deadly weapon. A second-degree felony carrying a sentencing range of 2 to 20 years in state prison, depending on the defendant's criminal history and the severity of the victim's injury. North took the case on appointment because Rook couldn't afford private counsel, his savings having been drained by legal fees from his ongoing custody battle with his ex-wife. And her first impression, formed during their initial interview in the holding cell at Granite County Jail, was that Rook was terrified, not of prison, though he should have been, but of losing his daughter, a 7-year-old girl named Sparrow, whose mother had full custody and a restraining order based on prior verbal altercations that Rook insisted were misunderstandings, blown out of proportion by a vindictive ex-wife who wanted to erase him from the child's life. He was not a sympathetic defendant in the traditional sense. His record included a prior misdemeanor assault from 6 years ago, a case involving a bar fight where he'd shoved another patron into a jukebox and been sentenced to community service. A dismissed domestic disturbance call from 3 years ago, one that his ex-wife had reported but declined to prosecute, and a speeding ticket that somehow escalated into a resisting arrest charge that was later plea bargained down to a fine after. Body cam footage showed the officer's commands had been unclear and contradictory. But North believed, as she told Slate during their first negotiation session in the cramped conference room adjacent to the prosecutor's bullpen, that Rook's conduct in the parking lot was reactive, stupid, and dangerous, but not premeditated, that he'd pulled the knife to intimidate rather than to injure, and that the injury to Tennant's arm was incidental rather than intentional. A fact that should, she argued, weigh heavily in favor of a lenient resolution. Slate, for her part, opened negotiations at a recommended sentence of 5 years in state custody with eligibility for early release after 3, citing Rook's prior record and the use of a weapon in public, both of which made him, in her view, a danger to the community and unworthy of leniency. North countered with a proposal for pretrial diversion. If Rook completed anger management counseling and stayed out of trouble for 18 months, the charges would be dismissed entirely, leaving him without a felony conviction that would destroy his livelihood and his custody prospects. Slate rejected that within an hour, citing victim input. Tennant had written a letter to the prosecutor's office saying he feared for his safety, that he couldn't sleep without replaying the moment the knife blade flashed in the sunlight, and that he wanted accountability, not leniency, not some slap-on-the-wrist program that would let Rook walk away as if nothing had happened. Over the next 6 weeks, the two attorneys negotiated incrementally, moving in half steps toward a middle ground neither side liked, but both could live with. 4 years, then 2 years with work release, then 18 months with a felony on the record, but no active custody time. And finally, after North provided Slate with documentation of Rook's custody battle, court orders, therapist reports, a handwritten letter from Sparrow's teacher describing how the girl cried every time her father missed, a scheduled visit, Slate agreed to recommend probation, counseling, restitution for medical costs, and a guilty plea to the original charge, with sentencing left to the judge's discretion within the probation framework. The deal was memorialized in writing on official letterhead, signed by Rook in blue ink, with North's hand steadying the page, countersigned by Slate, and filed with the court 10 days before today's hearing. North believed it was a fair resolution, one that balanced Rook's culpability with his capacity to rehabilitate, and the practical reality that Tennant's injury, while real and traumatic, was not life-altering. No permanent scarring, no nerve damage, no disability that would haunt him for decades. What North did not anticipate, what she failed to consider in the exhaustion of managing 16 active files and 2 upcoming trials, was that Judge Keystone would view the deal as an abdication of accountability, a capitulation to defense pressure that undermined the seriousness of brandishing a weapon in public, or that Keystone would suspect, correctly, as it turned out, that North had lobbied for that deal in a conversation that occurred outside the presence of opposing counsel, in violation of the ex parte communication rule that forms the backbone of judicial fairness. The Chamber's conversation had been brief, almost offhand, the kind of exchange that happens a dozen times a day in courthouses across the country and rarely gets noticed unless someone decides it matters. North had appeared in Keystone's office, a wood-panelled room lined with law books and framed certificates, to discuss a continuance in an unrelated felony theft case, State versus Carver, where her client had been hospitalized for a mental health crisis and couldn't attend the scheduled hearing. Keystone granted the continuance without objection from the prosecution, and as North was gathering her files and preparing to leave, the judge asked, her tone casual, "Anything else pressing on your docket this month?" North, exhausted and juggling too many cases with too few hours in the day, mentioned Rook's case in a single sentence. Sentencing on the assault plea next week. Client's a single dad. Custody situation is fragile. Probation would let him keep working and parenting. Keystone had nodded, said nothing more than, "I see," and North left, thinking nothing of it, believing she'd simply answered a routine question about her workload. It was not a formal argument. There was no motion, no briefing, no opportunity for Slate to respond, or even to know that the conversation had occurred. But it was enough to plant a seed, to introduce information about Rook's personal circumstances into the judge's mind at a moment when that information should have been presented on the record, subject to cross-examination and rebuttal. And now, 3 days later, Keystone is raising it in open court, forcing North to account for a conversation that, by its nature, violated the rule prohibiting ex parte communications on substantive matters pending before the court. The rule exists to ensure fairness, to guarantee that both sides in an adversarial proceeding have equal access to the decision-maker and equal opportunity to present their case. If one attorney gets to speak to the judge without the other present, the playing field tilts, the integrity of the process erodes, and appellate courts lose confidence that the trial judge's decision was based on the record, the evidence, the arguments, the legal briefs, rather than private persuasion delivered in a moment when no one else was watching. North knows this. She teaches criminal procedure as an adjunct at the State University Law School 2 nights a week, and she has lectured students on the importance of transparency in judicial communications, on the dangers of ex parte contact, on the need to preserve not just the reality of fairness, but the appearance of fairness, because public trust in the judiciary depends on the belief that judges decide cases based on what happens in open court, not on whispered conversations behind closed doors. But knowing the rule and living by it under the pressure of a 60-hour work week, mounting student loans, and a caseload that leaves her eating granola bars at her desk for dinner are different things. And now she's standing in the wreckage of her own mistake, watching as the plea deal she spent 6 weeks negotiating unravels in real time. Slate's voice cuts through the silence, sharp and precise. "Your Honor, I was not present for any conversation in chambers regarding this case, and I was not notified of any such conversation until this moment." Her tone is measured, careful, professionally calibrated to sound concerned rather than accusatory. But there's a hardness beneath it, because Slate understands immediately that if the judge relied on information provided ex parte to shape her view of the case, to form an opinion about whether Rook deserved leniency, then the entire plea agreement is tainted, and any sentence Keystone imposes could be challenged on appeal as the product of improper influence rather than neutral evaluation of the facts and law. Keystone nods slowly and turns back to North. Ms. North, I'm giving you an opportunity to clarify. Did you, in our meeting on the 21st, reference this defendant's custody situation in the context of arguing for leniency in sentencing? North swallows, her throat dry, her hands trembling slightly as she grips the edge of the counsel table and makes the only choice available to her. She tells the truth. Your Honor, I mentioned Mr. Rook's custody circumstances briefly during our scheduling discussion for the Carver matter. I did not intend it as advocacy, and I did not request that the court take any action based on that information, but I acknowledge that I should not have raised it outside Ms. Slate's presence, and I apologize to the court and to opposing counsel. The courtroom is silent except for the hum of the ventilation system and the faint scratching of the court reporter's machine. Rook looks at North, his eyes wide, confused, because he has no idea what ex parte means, or why his attorney is apologizing for something that sounds like she was trying to help him, trying to make sure the judge understood that he's not just a criminal defendant, but a father, a person with responsibilities and relationships that matter. Keystone's expression hardens, the lines around her mouth deepening, and she says, her voice carrying the weight of institutional authority, Ms. North, the rule against ex parte communication is not a technicality designed to make attorneys' lives more difficult. It is a safeguard of the integrity of these proceedings. When you referenced your client's circumstances to me privately, you put me in an impossible position. If I accept this plea and impose probation, the public and the appellate courts will reasonably question whether I did so because of information improperly provided outside the adversarial process. If I reject the plea or impose a harsher sentence to avoid that appearance, I punish your client for your ethical lapse. Either way, the process is compromised. She pauses, letting the words settle, and then adds, I am not convinced that I can proceed fairly with sentencing today, and I am considering whether to recuse myself from this matter and refer it to another judge in this district. North's stomach drops, because recusal means delay, means uncertainty, means Rook stays in limbo for weeks or months, means the plea deal might fall apart entirely if a new judge views it as too lenient without the context North foolishly tried to provide in that 30-second conversation. But before she can respond, before she can formulate an argument or a motion or even a plea for the judge to reconsider, Slate speaks again, her voice calm but unyielding. Your Honor, the state requests that if the court is concerned about the integrity of this proceeding, the court reject the plea agreement entirely and allow the parties to renegotiate or proceed to trial. The victim in this case, Mr. Tennant, deserves confidence that any resolution was reached on the merits, not through improper advocacy conducted outside the record and without the state's knowledge or ability to respond. It's a tactical move, and a devastating one. Slate is leveraging Keystone's stated concern about fairness to kill a deal she never liked in the first place, to force Rook back to the negotiating table, or better yet from the prosecution's perspective, to trial where a jury might be far less sympathetic than a judge, influenced by talk of custody and fatherhood. North has no procedural ground to object because the judge has inherent authority to reject a plea agreement if it undermines public confidence in the fairness of the judicial process, and because North herself has admitted on the record that she violated the ex parte rule, however inadvertently. Rook leans toward North and whispers, his voice tight with panic, "What's happening? Are they taking the deal away?" North doesn't answer immediately because she's calculating, running through options in her mind. whether she can file a motion to compel acceptance of the plea, whether she can argue that rejection would constitute an abuse of discretion, whether there's any case law supporting the proposition that a minor ex parte communication can be cured without blowing up the entire agreement. But the truth is that once a judge raises ex parte communication on the record, the damage is done. Every ruling from that point forward is shadowed by the suspicion that it was influenced by improper contact, and no amount of after-the-fact justification can fully restore the appearance of neutrality that the rule is designed to protect. Keystone glances at the clock on the wall, then at the lawyers, then at Rook, whose face has gone pale, and says, "Here's what we're going to do. I'm not going to recuse at this time, but I'm going to continue this sentencing for 2 weeks to allow the parties to file briefs on whether the plea agreement should be accepted in light of the ex parte issue, and whether any curative measures, such as a hearing on the record to establish the factual basis for the custody argument, would restore confidence in the process. Ms. North, you will also file a written response explaining the nature and content of our chamber's conversation. And, Ms. Slate, you will have an opportunity to respond to that filing. In the interim, Mr. Rook will remain on bond under the same conditions as before. We are adjourned." Woo. The gavel comes down with a sharp crack, and North feels the weight of it in her chest, because what Keystone has just done is turn a straightforward sentencing hearing into a procedural minefield, where the outcome is no longer about Rook's culpability or his capacity for rehabilitation, but about whether the system itself can be trusted, whether the public can have confidence that sentences are imposed based on law and evidence rather than private lobbying. Outside the courtroom, in the marble-floored hallway, where the afternoon light slants through high-arched windows and dust motes drift lazily in the air, Rook turns to North and asks, his voice shaking with anger and fear, "Did I just lose my deal because you talked to the judge?" North wants to lie, wants to reassure him that everything will be fine, that this is just a procedural hiccup, but she can't, because she respects him enough to tell the truth, even when the truth makes her look incompetent. "It's complicated," she says slowly. "The judge is concerned that I gave her information about your case without the prosecutor present, which violates a rule designed to keep the process fair for both sides. I made a mistake. I thought I was just having a casual conversation, but legally it counts as improper advocacy, and now we have to fix it." Rook's face twists with a mixture of anger, betrayal, and terror, and he says, his voice rising, "I trusted you. I took this deal because you said it was the best I could do, and now you're telling me it might blow up because you broke a rule." North nods, unable to meet his eyes, and says, "I'm sorry. I'm going to do everything I can to fix this, but I can't make promises I'm not sure I can keep." Rook stares at her for a long moment, then turns and walks away, his boots echoing on the marble floor, leaving her alone with the knowledge that she has jeopardized not just a case, but a life, not just a plea agreement, but a father's relationship with his daughter. Over the next 2 weeks, North drafts and redrafts her brief, a 12-page document that walks a tightrope between candor and self-preservation. She discloses the full content of the chamber's conversation, quoting her own words as precisely as she can remember them, explains that it lasted less than 30 seconds and was not intended as formal advocacy, and argues that it was inadvertent rather than strategic, the product of exhaustion and poor judgment rather than deliberate manipulation. She proposes a curative measure, a hearing on the record where she would present the custody documentation, the court orders, the therapist's report, the teacher's letter, and Slate would have full opportunity to cross-examine witnesses and challenge the relevance of the evidence, so that Keystone could consider the information in a procedurally proper manner with both parties present and the public able to observe. She cites cases from appellate courts in other jurisdictions holding that minor ex parte communications can be cured by disclosure and an opportunity for the opposing party to respond, and she argues that recusal or rejection of the plea would be disproportionate remedies that punish the defendant for counsel's error in violation of principles of fairness and proportionality. She files the brief electronically at 11:58 p.m. On the deadline, her eyes burning from staring at the screen, and then lies awake for hours, wondering whether she's done enough, whether Keystone will accept the proposed solution, or whether the judge will decide that the only way to restore confidence in the process is to blow up the deal entirely. Slate's responding brief is shorter, 8 pages, and sharper, cutting through North's arguments with surgical precision. She argues that any reliance on ex parte information taints the proceeding irreparably, that the only way to restore integrity is to reject the plea and start over with full transparency, and that the victim's right to a fair process, to know that the sentence imposed reflects a neutral assessment of the facts rather than private lobbying by defense counsel, outweighs the defendant's interest in a lenient sentence obtained through improper means. She does not explicitly call for sanctions against North, does not request that the State Bar's disciplinary counsel investigate or prosecute, but the implication hovers between the lines. This was not an accident. This was advocacy dressed up as small talk, a deliberate attempt to influence the judge outside the adversarial process, and it worked until it didn't. Slate attaches as an exhibit a copy of the victim impact letter Tennant submitted 3 months earlier, in which he describes his ongoing fear of encountering Rook in public, his difficulty sleeping, his sense that the criminal justice system has failed him by allowing a man who threatened him with a knife to walk free with nothing more than probation. The letter is devastating, and North knows it will carry weight with Keystone because it reframes the case not as a story about a flawed father trying to stay connected to his daughter, but as a story about a victim whose trauma has been minimized by a defense attorney willing to bend the rules to get what she wants. When the parties return to court 2 weeks later, on a cold morning when frost coats the windows and the gallery is packed with spectators, defense attorneys, prosecutors, law students, reporters from the local legal blog, Keystone takes the bench, and the room falls silent. She reads both briefs into the record by summary, acknowledging the arguments on each side, and then delivers her ruling in a voice that carries no emotion, only the weight of institutional authority. "I have carefully considered the arguments of both parties," she begins. Ms. North's Chambers communication, while brief, addressed a substantive issue, the defendant's personal circumstances and their relevance to sentencing. That is precisely the kind of information that must be presented on the record, subject to cross-examination and rebuttal, not whispered in passing during a scheduling discussion. The rule against ex parte communication exists because even the appearance of impropriety undermines public confidence in the judiciary, and I cannot ignore that principle simply because the communication was short or unintentional. North's heart sinks, but Keystone continues. "However, I am persuaded that the appropriate remedy is not to reject the plea agreement outright, which would punish the defendant for his attorney's mistake, but to impose a condition. Ms. North will present the custody documentation and therapist's letter on the record today in open court, and Ms. Slate will have full opportunity to cross-examine the witnesses or challenge the relevance of the evidence. If, after that hearing, I determine that the information supports the lenient sentence proposed in the plea agreement, I will accept the plea and impose probation. If I determine that it does not, I will reject the plea, and the parties may renegotiate or proceed to trial. It's a compromise, an attempt to split the difference between rejecting the plea entirely and accepting it without addressing the underlying ethical breach. But it's also a rebuke, Because what Keystone is saying, in effect, is that North's shortcut has cost everyone time, money, and trust, and the only way to repair the damage is to do the work that should have been done in the first place. The hearing proceeds with the formality of a trial. North calls Rook's daughter's therapist, Dr. C. Ember, a licensed clinical social worker who has been treating the child for 18 months. Dr. Ember testifies, her voice calm and professional, that the child Sparrow has attachment issues stemming from inconsistent parenting by both parents during a contentious divorce, that Rook has been attending scheduled visits reliably for the past year and has made genuine progress in understanding how his volatility affects his daughter, and that incarceration would disrupt the therapeutic relationship and undermine the progress the child has made in feeling secure with her father. Slade cross-examines aggressively, pointing out that Rook's prior arrests and the restraining order suggest a pattern of volatility that poses a risk to the child's long-term well-being, and asking whether Dr. Ember has any evidence that Rook won't reoffend, won't lose his temper again in a moment of stress or humiliation. Dr. Ember acknowledges that she cannot predict future behavior with certainty, that therapy is not a guarantee against recidivism, but insists that the therapeutic relationship depends on stability and continuity, and that probation with mandatory counseling offers a better chance of rehabilitation than incarceration, which would sever the father-daughter bond at a critical developmental stage. North also submits the Custody Evaluator's Report, a 30-page document prepared by a court-appointed psychologist which recommends supervised visitation but notes that Rook has complied with all court orders, has attended parenting classes, and has demonstrated a genuine effort to repair his relationship with his daughter despite the obstacles created by his criminal record and his ex-wife's hostility. Slate argues in rebuttal, standing at the podium with her hands gripping the edges, that the victim tenant also has a right to feel safe, to walk through a parking lot without fear of encountering a man who once threatened him with a knife, and that probation sends a message that wielding a weapon in public carries no serious consequence, that violence can be excused if the perpetrator has personal problems or family responsibilities. She reads portions of Tennant's impact letter aloud, her voice steady but carrying an undertone of controlled anger. "I can't sleep without replaying the moment he pulled that knife. I can't go to the hardware store without looking over my shoulder. I deserve to know that the man who did this to me faced real accountability, not just a lecture and some counseling sessions." The arguments are familiar, well-worn, the kind of adversarial exchange that happens in courtrooms every day. But they carry a different weight now because everyone in the room knows that this hearing is not just about Rook. It's about whether the system can self-correct when an attorney makes a mistake, whether a judge can impose fairness after the process has been compromised, and whether transparency and procedure can rebuild trust that was lost in a 30-second conversation behind closed doors. Keystone takes a 15-minute recess, retreating to her chambers while the gallery murmurs, and North sits at the counsel table with her head in her hands. And when the judge returns, she delivers her decision with the same calm, measured tone she's maintained throughout. Having heard the evidence on the record, in the presence of both parties and the public, I am satisfied that the defendant's custody circumstances are relevant to sentencing and that probation, combined with mandatory counseling and restitution, is an appropriate resolution that balances accountability with the goal of rehabilitation. I accept the plea agreement, and I impose the following sentence: 3 years of supervised probation, 100 hours of community service to be completed within the first year, completion of a certified anger management program within 6 months, restitution to the victim in the amount of $200 for medical expenses and lost wages, and a permanent no-contact order prohibiting any communication or proximity to the victim. Mr. Rook, if you violate any term of this probation, if you miss a meeting with your probation officer, if you fail to complete the counseling, if you come within 500 feet of Mr. Tennant, you will be brought back before this court and you will serve the full term of incarceration authorized by the original charge, which is up to 20 years. Do you understand? Rook nods, his eyes wet with tears of relief and exhaustion, and says, his voice breaking, "Yes, Your Honor, thank you." Keystone nods, then turns to North, and the courtroom seems to hold its breath. Ms. North, I am not imposing sanctions at this time, but I am referring this matter to the State Bar's Office of Disciplinary Counsel for review of whether your conduct violated Rule 3.5 of the Rules of Professional Conduct, which prohibits ex parte communication with a judge on the merits of a pending case. You will receive notice of any investigation in due course, and you will have an opportunity to respond. I want to be clear that I believe your apology is sincere and that you did not act with malicious intent, but sincerity does not undo the harm to the process, and the Bar has an obligation to ensure that attorneys understand and comply with the ethical rules that protect the integrity of the judicial system. We are adjourned. The gavel comes down, final and irrevocable, and North feels the weight of it settle over her like a shroud. A Bar referral is not a finding of misconduct. It's an investigation, a review, a chance to explain and defend. But it's also a stain, a public record that she violated a rule, even if the ultimate disposition is a private warning or dismissal, rather than suspension or disbarment. She nods and says, her voice barely above a whisper, "I understand, Your Honor, and I apologize again to the court, to Ms. Slate, and to Mr. Tennant." "Nti." Keystone's expression softens almost imperceptibly, and she says, "I believe you do understand, Ms. North, but understanding is not enough. The rules exist for a reason, and part of being a professional is internalizing them so deeply that you follow them even when you're exhausted, even when you're juggling too many cases, even when a shortcut seems harmless. I hope this experience will serve as a reminder." North nods again, unable to speak, and gathers her files with shaking hands. Rook approaches her in the hallway afterward, his face a complicated mixture of gratitude and wariness, and says, "Thank you for getting me probation. I know you made a mistake, but you also fought for me, and I appreciate that. But I'm going to find a different lawyer for my custody case. I need someone I can trust completely." The words sting more than the Bar referral, more than Keystone's public rebuke, because they're a vote of no confidence from the person she was trying to help, a reminder that trust, once broken, is difficult to rebuild even when the outcome is favorable. The fallout ripples outward over the following weeks and months. That evening, the local legal blog run by a retired appellate judge publishes a post titled, "Keystone Accepts Plea After Ex Parte Controversy, Refers Defense Attorney to Bar," and within hours it's picked up by the statewide legal news service and shared in private Bar Association listservs, where attorneys debate whether Keystone's remedy was appropriate or whether she should have rejected the plea entirely to send a clearer message. North receives calls and emails from colleagues, some offering support and sharing their own stories of mistakes made under pressure, others asking pointed questions about how she could have been so careless, so naive, so willing to risk her career and her client's case for the sake of a 30-second conversation. Rook texts her a single follow-up message 3 days later. "Started my anger management class. It's harder than I thought, but I'm doing it. Thanks again." The message is brief, almost perfunctory, but it carries a weight of closure, a sense that he's moving forward with his life and leaving her behind. Slate, for her part, tells her supervisor that she's satisfied with the outcome. The plea was accepted on the record with full transparency. The victim's concerns were acknowledged in the restitution order and the no-contact provision. and the defense attorney was held accountable without the case being dismissed or retried. But privately, in a conversation with a colleague over coffee, she admits that she wonders whether Keystone's compromise was the right call, whether rejecting the plea entirely would have sent a clearer message about the importance of ethical rules, or whether the judge's decision to accept the plea after the curative hearing was itself influenced, consciously or unconsciously, by the very information that North provided ex parte, making the entire exercise a performance designed to create the appearance of fairness without its substance. 3 months later, North receives a letter from the Office of Disciplinary Counsel on heavy cream-colored stationery with the State Bar's seal embossed at the top. The letter is formal, impersonal, written in the passive voice that characterizes institutional communications, but its message is clear. After investigation, including review of the court transcripts and interviews with Judge Keystone and Prosecutor Slate, the office has determined that North's conduct constituted a minor violation of Rule 3, 5B of the Rules of Professional Conduct, which prohibits lawyers from communicating ex parte with a judge about the merits of a pending matter, but that it did not rise to the level warranting public discipline, such as suspension or disbarment. The letter includes a private admonition, a formal record that will remain in her disciplinary file for 5 years, and a reminder that any future violation of the ex parte rule or any other ethical provision will be treated more severely and may result in public sanctions. North files the letter in a locked drawer in her desk and tries to move on, tries to return to the rhythm of motion practice and plea negotiations and trial preparation. But the case stays with her, a reminder that the line between advocacy and impropriety is thinner than she once believed, and that crossing it, even for 30 seconds in a judge's chambers, even with the best of intentions, can turn a straightforward sentencing into a procedural battle that consumes weeks, damages reputations, and forces everyone involved to confront the uncomfortable truth that the appearance of fairness is as important as fairness itself. She thinks about Rook sometimes, wonders whether he completed his anger management program, whether he kept his probation without violations, whether his relationship with his daughter improved, or whether the damage from the divorce and the criminal case was too deep to repair. She doesn't know, because she never heard from him again after that text message, and she doesn't reach out because she understands that he needs to move forward without her, without the reminder of the mistake that nearly cost him everything. She thinks about Tenant 2, the victim whose trauma was minimized in the rush to negotiate a lenient plea, and she wonders whether the no-contact order and the restitution check brought him any sense of closure, or whether he still lies awake, replaying the moment the knife blade flashed in the sunlight. She thinks about Keystone, and whether the judge second-guesses her decision to accept the plea after the curative hearing, whether she wonders if the entire process was tainted beyond repair, and if her compromise satisfied no one while creating a precedent that other judges and attorneys will struggle to interpret and apply. Judge Keystone, for her part, views the case as a teaching moment, a cautionary tale about the importance of procedural integrity, and she references it carefully, without naming parties or revealing identifying details, during a continuing legal education seminar on judicial ethics 6 months later. The seminar is held in a hotel conference room downtown, attended by 50 judges and lawyers who sit in rows of uncomfortable chairs and take notes on laptops while Keystone stands at a podium and speaks about the ex parte rule, its history, its purpose, and the challenges of enforcing it in an era when informal communication between attorneys and judges is common and often unavoidable. The rule against ex parte communication is not about punishing attorneys for minor slip-ups, she tells the audience, her voice carrying the authority of someone who has wrestled with these issues in real cases, with real consequences. It's about preserving the integrity of the adversarial process, which depends on both sides having equal access to the decision-maker and equal opportunity to present their case. When one attorney gets to make their case privately, even for 30 seconds, even in a conversation that seems casual and inconsequential, the process is no longer adversarial. It's a conversation, and conversations don't produce justice. She pauses, letting the words sink in, and then continues. But the remedy has to fit the violation. In the case I'm thinking of, I could have recused myself, which would have delayed the defendant's sentencing indefinitely and potentially cost him the plea deal that both parties had worked hard to negotiate. I could have rejected the plea outright, which would have punished the defendant for his attorney's mistake and forced either a trial or a renegotiation that might have resulted in a harsher sentence. Or I could have imposed immediate sanctions on the attorney, which might have satisfied the prosecutor and sent a strong deterrent message, but would not have addressed the underlying fairness concern, or given the defendant confidence that the sentence was based on evidence rather than punishment for counsel's error. Instead, I chose transparency. I put the ex parte communication on the record, required the attorney to present the information properly in open court with the opposing party present, and referred the attorney to the bar for disciplinary review. It wasn't perfect. No remedy in this situation can be perfect, but it was procedurally sound, and it preserved public confidence that the sentence was based on the record rather than on private advocacy. 3. The seminar attendees nod, and a few take notes. And during the break, several judges approach Keystone to ask follow-up questions about how she decided on that particular remedy, whether she worried about creating a precedent that would allow other attorneys to cure ex parte violations through after-the-fact hearings, whether the curative process was itself tainted by the knowledge that the judge had already been exposed to the information she was supposedly evaluating neutrally. Keystone answers as best she can, acknowledging the tensions and uncertainties, but privately she wonders, as she stands there with a cup of bad coffee cooling in her hand, whether she made the right call, whether the compromise she crafted was just another form of avoidance, a way to impose accountability without fully confronting the fact that her own chamber's door was open to a conversation that should never have happened, that she should have stopped North the moment the defendant's name was mentioned and said, "We can't discuss this without opposing counsel present." The fact that she didn't, that she listened and nodded and said, "I see," makes her complicit in the breach, and that knowledge weighs on her in the quiet moments when she's alone in her chambers reviewing case files and wondering whether justice in the end is about perfect adherence to rules or about finding practical solutions that balance competing values and imperfect human beings. The case file for State V's. Rook sits in a banker's box in a climate-controlled storage room in the basement of Atlas Hall, labelled and indexed according to the court's retention schedule, waiting for the statutory period to expire before it's transferred to the state archives or destroyed. Inside the box are the plea agreement with its careful legalese, and the signatures in blue ink, the sentencing transcript with every word preserved in the court reporter's meticulous shorthand, the therapist's testimony and the custody evaluator's report, the victim's impact letter with its raw descriptions of fear and trauma, North's brief explaining and apologizing for the ex parte communication, and Slate's brief arguing for rejection of the plea. Taken together, they tell a story about how a 30-second conversation in a judge's office can spiral into a procedural crisis that consumes weeks of attorney time and judicial resources. How lenient deals can survive ethical breaches if transparency is restored and both sides are given an opportunity to present their case on the record, and how the rules that govern courtroom conduct exist not to make lawyers' lives harder or to create technicalities that derail justice, but to ensure that Every defendant, every victim and every member of the public can trust that sentences are imposed in the open, where everyone can see the evidence and the arguments and the reasoning, and where the judge's decision is based on law rather than private persuasion. The file does not record what happened to Rook after probation, whether he completed his anger management and community service, whether he stayed out of trouble, whether his relationship with his daughter healed or remained fractured by the years of conflict and instability. It does not record whether North ever fully regained the confidence she lost the day she stood in Keystone's courtroom and admitted she had broken a rule she teaches her students never to break, or whether the bar referral and the private admonition shadowed her career and made her second-guess every conversation, every motion, every strategic choice. It does not record whether Tennant, the victim, felt that justice was served by the probation sentence and the restitution check, or whether he still thinks about the parking lot and the folding knife and the moment his arm caught the truck bed and started to bleed, or whether the no-contact order brings him any comfort when he walks through the hardware store and wonders if he'll turn a corner and see Rook's face. But the file does record, in meticulous, bloodless detail, the moment when a judge turned a lenient plea deal not into hard time, but into hard scrutiny, a public reckoning with the distance between good intentions and ethical practice. A reminder that in a courtroom, the only conversations that matter are the ones that happen on the record, where every word is transcribed, every argument is tested, every piece of evidence is subject to cross-examination, and every decision is made in the light, rather than in the shadows of chambers and hallways and informal exchanges that seem harmless until they're not. If you've ever wondered why courtroom rules feel rigid and unforgiving, why judges and attorneys obsess over procedure and formality and the precise language of motions and objections, this case is your answer. The rules exist because the alternative, private conversations, unopposed advocacy, backroom deals, influence peddled in whispers, erodes trust faster than any bad verdict, any harsh sentence, any controversial ruling ever could. The machinery of justice is slow and cumbersome and frustrating, but it's designed that way on purpose, built to withstand the pressure of human fallibility and self-interest, and the constant temptation to take shortcuts that seem efficient in the moment but undermine the system's long-term legitimacy. Drop a comment if you've seen a case where procedure became the story, where the fight for fairness happened not in front of a jury weighing evidence, but in the margins of a transcript, one objection at a time, one ethical rule at a time, one hard choice at a time, about whether to do the work the right way or to take the shortcut and hope no one notices.